You wake up, reach for your phone, and open your banking app before you're even fully conscious. Yesterday, your balance was a few $100s. Today, it says $102.47. You refresh the page. Still there. You close the app, reopen it, and check the account number. Definitely your account. No email, no explanation, no mysterious relative announcing an inheritance. Just an extra $100,000 sitting underneath your name as if it has always belonged there. Before we go any further, lock in your honest first reaction. Do you A. Leave it exactly where it is? B. Move it into another account just in case? C. Pay off every debt you have before anyone notices? Or D. Contact the bank immediately? You do not have to admit your answer yet. Just remember it, because by the end of this story, one of those choices may look much more dangerous than it does right now. Here is the short answer. A number appearing in your account usually does not make the money yours, but that is the easy part. The interesting questions are, what happens next? Can the bank remove the money without your permission? Does moving it become evidence of theft? What if you genuinely believe the payment was meant for you? And how did a group of sophisticated lenders once persuade a federal judge that they could keep approximately $500 million sent to them by mistake? Same type of error. Completely different legal outcomes. And the difference was not simply how much money was involved. To understand it, we need to start with two people who faced a much more believable version of your imaginary $100,000. In May 2019, Robert and Tiffany Williams lived in Pennsylvania. Before anything unusual happened, their bank account reportedly contained $121. Then, because a bank employee entered the wrong account information, a $120,000 deposit intended for an investment firm landed in the Williamses' account. Their new balance was approximately $121,121. Now, I want to be fair to them for a moment. If I opened my banking app and unexpectedly saw 6 figures, I would probably refresh it twice as well. I might stare at it for an embarrassing amount of time. Simply being confused, or even briefly excited, is not the legal problem. What matters is what happens after the surprise wears off. According to the police complaint, the Williamses did not contact the bank. Over approximately 2.5 weeks, they began spending the money. There was reportedly a $15,000 down payment on a Chevrolet Traverse. Then 2 all-terrain vehicles, a camper, a trailer, a race car, bills and cash purchases. They also allegedly gave around $15,000 to friends. They did not test the mysterious money by buying a cup of coffee. They went directly to vehicles, recreational equipment, and 5-figure transfers. Their previous balance made the scale of the mistake extremely difficult to miss. Then, on June 20th, the bank discovered what had happened. And this is where the fantasy ends very quickly. The bank reversed the mistaken $120,000 credit. Because much of the money had already been spent, contemporary reports said the Williams' account was left approximately $107,000 in the negative. That distinction matters. Spending mistaken money does not necessarily stop the bank from reversing the original entry. The bank can correct a number on its ledger much faster than someone can reverse the purchase of a car, a camper, or an ATV. The bank reportedly contacted Tiffany. She initially said that she would discuss repayment with her husband. According to the complaint, later attempts to contact the couple were unsuccessful, and the matter eventually reached the police. Then came the fact that made their legal position substantially worse. According to the police affidavit, both Robert and Tiffany acknowledged that they knew the money did not belong to them. They were subsequently charged with felony theft-related offenses, including theft and receiving stolen property. Later reporting said they received probation and community service. So let's pause the story here, because this is where the internet usually compresses 3 different legal questions into one sentence. You spent money that wasn't yours, so that's theft. The actual structure is more careful than that. First, who legally owns the money? Second, what can the bank do to recover or reverse it? Third, has the recipient behaved in a way that satisfies the elements of a criminal offense? Those questions overlap, but they are not identical. This case involved Pennsylvania law. Other states and countries use different criminal statutes, restitution rules, and banking agreements. So I'm explaining the legal structure, not predicting anyone's individual case. Pennsylvania has a specific law called theft of property lost, mislaid, or delivered by mistake. In plain English, the prosecution is looking for three important ideas: knowledge, intent, failure to restore. Did the person know that the property had probably arrived by mistake? Did the person intend to deprive the real owner of it? And did that person fail to take reasonable measures to restore it? We do not need to turn this into a law school lecture. The practical point is simpler. The mistaken deposit itself is not a crime. Seeing it is not a crime. Being surprised by it is not a crime. The potential criminal case develops through what someone knowingly does afterward. That is why the alleged admission in the Williams case mattered so much. It gave investigators evidence that the spending was not caused by an innocent misunderstanding. But there is another distinction that is just as important. Suppose you genuinely did not notice an extra $400 in your account for several months. That lack of knowledge could matter enormously to the criminal question, because it is difficult to intentionally take something you never knew existed. It would not automatically make the $400 yours. The bank might still be able to correct the credit or seek repayment. Criminal intent and civil ownership are separate issues. Now let's return to your account and run through the choices you made at the beginning. Option A. You leave the entire $100,000 untouched. That does not magically transfer ownership to you. The bank can generally correct a mistaken credit once the error is discovered. But from a criminal perspective, merely leaving the entry untouched is very different from knowingly spending or concealing it. Option B. You move the money into another account. A transfer does not convert mistaken funds into legitimate income. Depending on the facts, moving the money could also become evidence that you knew it might disappear and wanted to place it somewhere else. That does not make every transfer automatically criminal. The reason for the transfer, what you believed, and what you did afterward would all matter. Option C. You use the money to eliminate your credit card balance, student loan, or mortgage. Emotionally, this may feel less serious than buying a race car. You are not walking away with a suitcase of cash. You are just making some numbers disappear. Legally and financially, however, the money has still been used for your benefit. If the bank then corrects the original credit, your debt to the credit card company may be gone while your bank account is now deeply negative. The money has not vanished. The obligation has effectively moved. And then there is option D. The bank, or someone claiming to represent the sender, contacts you. This creates a second trap that is arguably more dangerous because it can punish someone who is honestly trying to return the money. Imagine receiving a message that says, "We accidentally transferred $100,000 to you. Please send $90,000 back immediately, and you can keep $10,000 for helping us." That sounds suspicious when I say it slowly. In the moment, with the money apparently visible in your real banking app, it can feel convincing. But some fraudulent deposits and checks can appear available before the underlying transaction is finally rejected. If the original $100,000 later disappears while your separate $90,000 payment was genuine, you have not returned the same money. You have sent the scammer $90,000 of your own. That is why the lower risk pattern is usually extremely boring. The funds remain untouched. The claim is verified through the bank's official channels, and any correction occurs through a documented banking process rather than a separate payment to a stranger. That is general information, not individualized legal advice. But it reveals something important about this entire scenario. Both greed and panic can produce expensive decisions. So far, everything points toward one conclusion. Mistaken money normally goes back. But then we reach the case that appears to break the rule. In August 2020, Citibank was supposed to process approximately $7.8 million in interest payments for lenders connected to the cosmetics company Revlon. Instead, an operational error caused Citibank to transfer roughly $900 million. essentially paying off the entire outstanding loan using hundreds of millions of dollars from Citibank itself. Most recipients returned the excess payment. Several investment firms controlling approximately $500 million refused. And unlike the Williamses, these firms had a serious argument. They were genuine creditors. Revlon actually owed them money. The payment arrived from the bank responsible for administering that loan. From their perspective, this was not a random lottery deposit appearing in an unrelated checking account. Under a New York legal principle known as discharge for value, a creditor can sometimes retain a mistaken payment when it is presently entitled to that money and receives it without notice that anything is wrong. A federal district judge initially agreed with the lenders. For a while, they had a court ruling saying they could keep the disputed funds. Imagine the confusion at Citibank. A software error transfers hundreds of millions of dollars, and the first legal answer is effectively, the recipients may not have to give it back. But that was not the end. Citibank appealed, and in 2022, the Second Circuit reversed the decision for two central reasons. First, the unusual circumstances contained enough warning signs to place the lenders on notice that something might be wrong. Second, and even more importantly, the principal of the loan was not yet due. The lenders were legitimate creditors, but they were not presently entitled to receive that particular payment at that particular time. Eventually, being owed money is not the same as being entitled to collect it today. That is the distinction the earlier version of this story was missing. Good faith confusion can affect whether someone committed theft. It does not ordinarily create ownership of mistaken funds. And the narrow civil defenses that sometimes allow a recipient to keep a payment require much more than, "I thought the money might be mine." In the Citibank case, these were real lenders receiving money through a real loan relationship, and even their initial victory was reversed. Now compare the two cases. The Williamses had no underlying right to the $120,000. According to the police complaint, they recognized that fact, spent the funds, and later stopped responding to the bank. The Revlon lenders were genuinely owed substantial amounts of money. Their dispute concerned whether they were entitled to this payment now and whether the circumstances should have alerted them to Citibank's mistake. The amount of money was not the decisive distinction. The recipient's legal entitlement, knowledge, and conduct were. That same broad idea appears outside the United States, although the exact rules differ. England and Wales expressly address property received through another person's mistake in the Theft Act. Canadian theft law addresses fraudulent conversion more broadly. Each country structures the issue differently, which is why a viral American story is not automatically a statement of law everywhere else. But the practical distinction travels well. A bank balance is an accounting record. It is not, by itself, a certificate proving ownership. So let's return one last time to you. Holding your phone and staring at $100,047, can you keep it? Usually, not simply because it appeared in your account. Could the bank reverse it even if you have already spent it? In the United States, banks can generally correct mistaken credits. Depending on the transaction and account terms, that correction could create a negative balance, frozen funds, or a separate repayment claim. Does seeing the money automatically make you a criminal? No. Criminal exposure depends on the law where you live, and evidence of matters such as knowledge, intent, and what you deliberately did after discovering the mistake. And is there any conceivable situation in which mistaken money can legally remain with the recipient? There are narrow, jurisdiction-specific defenses, but they depend on real legal entitlement and precise facts, not on staying silent for 48 hours and hoping the bank forgets. If I saw this balance at 7 in the morning, I would probably experience the same 5 seconds of imaginary financial freedom as everyone else. The law does not require people to be emotionless. It cares about what happens after those 5 seconds, because a bank's mistake might survive for several days. The debt or legal record created by the response to it can survive for years. Now be honest. What was your first choice? Tell me in the comments.